Declaration of Independence is 5 pages. 3 of those pages are devoted to the listing of the grievances that they had against the government of their day. And we'll just not go through every one of them. You can see what some of those grievances were. And frankly, if you go home and you study these, you'll see that we're suffering many of those grievances all over again. So this is 3 out of the 5 pages, just a listing of the grievances. He's refused to assent to the laws. I mean, the supreme law of our land is the Constitution, and government refuses, to recognize and assent to the law, as we'll see.
Solution against big government.
He has erected a multitude of new offices and has sent hither swarms of officials to harass our people and eat out their substance.
Politicized. It's very corrupt, as they did.
Swarms of officials to harass our people and eat out their substance.
Imposing taxes on us without our consent. We've just seen the government give or lend public money or credit to private corporations for a decidedly private purpose without any authority to do so. There's absolutely nothing in the Constitution that authorizes the government to do what they're doing with public funds. To say nothing about the constitutionality of the Federal Reserve. We'll get to that. There's no authority in the Constitution, stealthily or otherwise, to develop a North American Union, to basically obliterate our northern and southern boundaries. Where do they get that authority? Anyway, now, so you get that, and then you have what the scholars call the capstone grievance. This is more than any other reason, I believe, why they decided to separate. This is the straw that broke the camel's back. It's what the scholars call the capstone grievance. It caps all the others. In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince or a government whose character is thus marked by every act which would define a tyrant is unfit to be the ruler of a free people. That short paragraph made it through every draft of the Declaration of Independence with the exception of the addition of one word, the word free, before people. So they had been petitioning since the end of the French and Indian War, and all of their petitions had been answered only with repeated injury. They were getting nowhere. And they decided then to separate. So the rest of this, it's basically, we're out of here. If you don't like it, come get us. Every stage of these oppressions, we petition for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A government whose character is thus marked by every act which may define a tyrant is thus unfit to be the ruler of a free people. And of course, a few years later, circulating the Constitution, and many of the states said, fine, except we'd like to see a Bill of Rights. The Bill of Rights actually has a preamble. Not every version of the Bill of Rights includes that preamble, but this is what it says. The conventions of a number of the states, having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the grounds of public confidence that the government will best ensure the beneficent end of its institution. This is an article out of the New Hampshire Constitution. It was in there originally, it's still there. Gives you some meaning as to the power of and the right of the people to redress, to hold their government accountable. This is what it says. Government being instituted for the common benefit, protection, and security of the whole community, and not for the private interest or emolument of any one man, family, or class of men, Therefore, whenever the ends of government are perverted and public liberty manifestly endangered, and all other means of redress are ineffectual, the people may, and of right, ought to reform the old or establish a new government. The doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of all mankind. To not resist against arbitrary power, to not resist against a government that has no authority, a government of free people that has no authority to do certain things, and it isn't doing what the people have mandated that it do. That's arbitrary power. That's ignoring a constitution. And we have means of redress, but if all other forms of redress are ineffectual, people may, and of right, ought to reform the old and establish a new government. And there's ways of doing that non-violently, by claiming and exercising the right under the First Amendment. And of course, if that accountability clause doesn't work, there's always the Second Amendment as another accountability clause, the other one. Some might say, you know, I've tried 3 times in court cases. I don't know, but for about 30 years, I've been doing the research, scrutinizing governmental behavior. The first 20 years in New York State, and the last 10 years at the federal level, scrutinizing governmental behavior, comparing its behavior with the requirements of our state and federal constitutions, and then wherever we've seen an impropriety or a conflict, we've unhesitatingly confronted them. Often that meant taking somebody to court. So I've been testing the attitude of the judiciary on this right to petition for redress, our right to hold the government accountable. Of course, they've been resisting, and I've been pressuring. And the first time I did this, I was in court, in a federal court. It had to do with a local matter where I live upstate. So there's the judge on the bench, and here's the attorney representing the government. And he says, Your Honor, it says right here the people have the right to petition the government, but that doesn't say the people have the right, or the government has to listen or respond. It just says the people have the right to petition, but it doesn't say the government has to do anything. So the judge looks at me and says, what do you got to say about that, Mr. Schulz? And I said, well, let's take a look at the 26th Amendment. It says the people have the right to vote. It doesn't say the government has to count the votes. Of course they got to count the votes, and of course they have to respond to these petitions. Why is it there? I mean, the founders weren't for wasting their time. I mean, they put it there for a reason. Every right that is not enforceable is not a right, and so of course it's enforceable. But for those who might say, well, it really doesn't say that, well, then I'd say look at the 9th Amendment. The 9th Amendment says the enumeration of the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. We have this right. If government steps outside the boundaries we've drawn around its power, we call them on it professionally, intelligently, and rationally with a well-crafted petition for redress of that grievance, and they ignore you. They're essentially saying, we ignore this, because silence is admission. When you have a duty to speak and you don't, you're admitting. Okay, and so if they're going to ignore this, if they're going to ignore, the Constitution, and they're going to go off and do something else, then fine, we don't owe them any support. We don't owe them